Welcome, everyone. This thing is making noise on me. As Kevin said, we are panel 3 of the, I don't know if he said this, but we are panel 3 of the March 2026 case call session. And to my right is Judge Colleen O'Brien, a longtime jurist, and to my left is Judge Adrian Young, a not so longtime jurist, but a very good person to work with. Our jobs consist of reading and writing. We have read everything you submitted. So now's the time to tell us something that might not be in your briefs. It's not time for you to get up and babble on for 30 minutes and read your brief. We've done that. Okay, I listen to audiobooks. I don't want to come to the office and listen to audiobooks as well. So we don't need you to rehash your brief. Now's your time to tell us something in addition, something new, something you might not have emphasized, some new case law, okay? You're not required to fill dead air time here. You don't need to rehash the facts. We're familiar. By court rule, you're allowed 30 minutes if opposed, 15 minutes on one side. We have a packed docket today. So we're hoping to get out of here by 4 or 5 o'clock, maybe. And it all depends, I guess, on the advocates. Keep in mind that the Court of Appeals makes an audio of every oral argument, and it's available to the public on our website. Actually, you can look at it on YouTube this afternoon. It takes a couple of hours, but you can go home and take a look at yourself. As a result, we caution counsel not to mention the name or location of any petitioner in an appeal involving a personal protection order or the name of any minor child in a termination of parental rights appeal. So without further ado, we'll begin today calling, actually they put tomorrow's case call list for me. So I'm not going to call case number 14. I'll call case number 1 for today. People versus Loreya Fluker, case number 372867.
Morning, Your Honors.
Good morning.
May it please the court, case number 37.
We know the case. Go ahead.
Yes, sir. My name is Loreya Fluker, defendant appellant appearing in propria persona. Before addressing the issues, I would like to briefly clarify for the record. In my brief, I inadvertently used the term plaintiff appellate. I respectfully request that the designation to defendant appellate. This posture of the case has remained clear from the record, and I ask the court to treat this as a harmless misnomer.
Don't worry about it. Go ahead. Get into the meat of your argument.
I also want to clarify the nature of my argument, sir. I fully understand that it is not the role of this court to retry the facts, to reassess witness credibility, or to reweigh evidence presented to the jury. The issues before this court are procedural and constitutional. They concern whether the trial court fulfilled its legal obligation once material reliability concerns and procedural defects were placed on the record. Many of the questions presented today are reviewed de novo, meaning this court independently examines whether the law was properly applied. To explain how these legal errors arose, I will briefly describe the sequence of procedural errors, beginning with the initial traffic stop and continuing through the trial court proceedings. Again, I do this not to relitigate the facts, but to demonstrate how procedural errors developed and compounded over time once the court was placed on notice. I will address 3 primary categories of error. Number 1, the introduction of materially false information into official reports. Number 2, the discovery violations and withheld exculpatory evidence. Number 3, the trial court's failure to act once these issues were raised on the record. Procedural irregularities beginning with the traffic stop. This case began with the traffic stop on October 13th,
Because your registration
2023
tags were,
in,
excuse me.
I'm sorry.
Because your registration tags were expired. We know the facts, okay?
Yes,
Get to
sir.
the heart of your argument.
I was not trying to read.
Okay.
I was just,
Go ahead.
this is just for,
All right, I know you're not a
for
lawyer.
a
You've done it.
cumulative,
You've done a wonderful job. Your briefing is outstanding.
I appreciate
Okay,
that,
and we've
sir.
read it.
Thank you.
All right, go ahead.
Yes, sir. Again, it was initiated by Police Officer Joshua Martin, badge 4091. I'm sorry, 4091. During the stop, I asked the officer what was the suspected crime. Officer Martin is seen on body camera labeling me as a sovereign citizen while requesting a supervisor. It is important to note that I am not seen on his body camera articulating to be a sovereign citizen. And Officer Martin would clarify during his trial testimony and earlier proceedings that I never claimed to be sovereign. And he would also articulate his behavior that day as quoted, not being department policy, but a common practice in the department in regards to respond this way with people who they profile as sovereign citizen. This characterization became a central narrative of the encounter and later proceedings. Nevertheless, the body-worn camera footage reflects Officer Martin informing responding officers that he had encountered a female sovereign citizen. This occurred before additional officers arrived on the scene, meaning the characterization shaped the way responding officers approached the encounter. The body camera footage also contained additional statements that are significantly procedural. At approximately the 12-minute mark of his hour-long body-worn camera, Officer Martin tells fellow officers that he has previously encountered women where he assumed to be sovereign citizens. At approximately the 26-minute mark, Officer Martin further explains to the responding officers that he had previously been disciplined by his superiors after dragging another woman from her vehicle during a similar encounter when she questioned the nature of the stop. I reference these statements not for the purpose of relitigating facts, but to demonstrate how Officer Martin's assumptions and prior experiences influenced how the encounter was framed. That framing then mitigated into official documentation and later proceedings. Number 2, the introduction of false information into official records. Following the incident, I was charged with assaulting 2 police officers. During these criminal proceedings, the officer in charge, Joshua Davis, made an admission that was central to the due process issued before this court. Officer Davis acknowledged that he signed the constitutional right certification of notification on October 14, 2023 at 9:15 a.m. And within that document, he included remarks stating that the defendant had claimed to be a sovereign citizen. However, that statement was not supported by the body-worn camera evidence. In other words, the officer in charge admitted placing information into a constitutional notification document that was not accurate. This is not a minor clerical discrepancy. The constitutional rights certification of notification is a document meant to memorialize the Constitution advisement status of the accused.
Did you argue, excuse me,
I'm so sorry, sir.
That's all right. Did you argue this in front of the jury?
Yes.
You represent, okay.
Yes, sir, I represented myself.
So I know you did. The jury heard all of this, correct? And it was they were the judges of credibility. The jury was, correct?
Sir, you're asking if the jury, can you repeat?
Was this evidence submitted to the jury?
All of that.
And did you argue this in front of the jury?
What I was able to, the jury never was able to understand the give me one moment,
that's fine.
sir. I'm just trying to gather my thoughts.
Yeah,
one moment.
no problem.
Respect.
It's pressure packed for attorneys, let alone someone here for the first time. See, we can't substitute
I,
our credibility determination for the jury's.
it's
So if
not,
the jury,
it was,
excuse me, if the jury weighed this evidence, we can't re-weigh it.
I'm not trying to retry any facts. It's not about the credibility at all. It was about introducing. I put the court on notice when material evidence was incorrectly entered into the record. I made that aware of the court. It was their duty to act on whether or not. It was their duty to act. They failed. The trial court failed to act when these issues
You're
were
saying
placed on the record, sir.
The trial court failed to exclude the evidence.
There was.
Talking about.
I am referring to the fact that the trial court used this evidence entered by Officer Davis, Joshua Davis, with a constitutional rights certification on October 14th. He entered this into evidence that had material, in fact, it was not accurate.
You point that out to the jury below?
Yeah.
Did you point that out to the court?
I've made it on record many times that that this documentation was inaccurate. And Officer Davis is heard on in the transcript saying that it was inaccurate, that this that I never said that I never claimed to be that it was false.
Okay.
That is
But
in
you
the record,
did argue
sir.
that below that it was false.
I have argued from day one that this is false, that this is that I've maintained my innocence, sir.
Right. Okay, I just want to clarify that you did argue this below. Okay. All right, go ahead.
Yes, sir.
All right. You're on point 2 or 3 points.
Yes, sir. Yes, sir. Again, the information of the introduction of false information into the official records were procedural. And Officer Martin's initial profiling during the stop directly influenced officer in charge official reporting, which informed the prosecutor's theory of the case. This chain of events meant that the prosecution proceeded based on a narrative that originated from an unsupported classification. Once this discrepancy was made clear on the record, the trial court had a duty to address the reliability implications of that documentation. The issue before this court is whether or not the officers acted improperly as a factual matter, but whether the trial court fulfilled its duty to ensure the proceedings were not relying on materially inaccurate information once the issue was raised. The third issue, withheld exculpatory evidence and discovery violations. Michigan Court Rule 6.201, the second major procedural error concerns mandatory discovery obligations under Michigan Court Rule 6.201. Discovery materials were requested approximately 180 days prior to me receiving, just weeks before trial. The record and the appendix reflect the following timeline. On March 25th, 2024, the prosecutor finally provided exculpatory evidence that had previously been withheld. On April 1st, 2024, the prosecutor sent additional discovery materials, completing the production. This occurred.
Talking about videos?
I'm sorry,
Are you
sir.
talking about the production of videos?
All of the evidence wasn't produced until weeks before the
videos,
trial.
correct. The videos?
All of the evidence that I received from the prosecution, sir, which included videos. Yes, sir.
All right.
This occurred roughly 2 weeks before the trial, despite the request being made 180 days earlier. These delays were raised on the record and brought to the court's attention multiple times. Under Michigan Court Rule 6.201, discovery obligations are mandatory, not discretionary. The rule exists to ensure that a defendant has adequate time to review the evidence, investigate inconsistencies, and prepare defense. When exculpatory evidence and discovery materials are withheld until shortly before the trial, the defense is deprived of a meaningful opportunity to investigate and to challenge the evidence.
Ms. Fluker, I hate to interrupt you again, but you have 15 minutes to argue because you're unopposed, and you're at about minute 13 now.
Yes, sir.
Okay.
Okay. The appellant question is not whether the evidence was pervasive. The question is whether due process was satisfied when the discovery rules were enforced, despite clear notice to the trial court. District court dismissal of underlying traffic citations. Another critical procedural issue involves the traffic citation that initiated the stop. On March 15th, 2024, I filed a motion to dismiss in the circuit court. In that motion, I provided documentation that the traffic ticket number P15106662 and the citation that initiated the stop had been dismissed entirely by the 36th District Court Judge Larry Williams. To support the motion, I submitted these documents, including the register of action of the district matter and the dismissal documentation from the district court. This documentation demonstrated that the underlying traffic offenses had already been dismissed. Despite this evidence, the prosecution filed a written response. In the emails, communications dated March 10th, Prosecutor Carmona informed me that the people would be objecting to the motion. Then on March 12th, the prosecution filed its written response to the court denying that the district court had dismissed the charges. Despite this documentary proof attached to my motion, this situation created a circuit court where presented with document evidence of dismissal and prosecutorial.
This is your double jeopardy claim, correct? You're at, according to my clock, you're at 10:18. I had you starting at 10:03, so you're at 15 minutes. But this is your double jeopardy claim that you're arguing, correct?
Yes, sir. I'm arguing that there are constitutional violations by the trial court. Yes, sir.
You're going to have to wrap it up.
Yes, sir. Their failure to act on the record of notice with reliability concerns of the material foundation throughout the proceedings. They were repeated notice of the material reliability concerns through the inaccuracies of official documentation, with the officer in charge admitting that, body cam evidence, contradicting statements in police reports, delayed production of exculpatory evidence, documented dismissal of the underlying traffic ticket. These issues were raised with motion, objections, emergency filings, the cumulative procedural effect, the pattern of procedural failures. The traffic stop was framed through unsupported profiling. Official.
You're repeating your argument now. You're over time. Okay. Judge O'Brien, do you have any questions?
No, thank you.
Any questions? I will say this. You did a wonderful job briefing and you did a wonderful job arguing.
Thank you, sir.
So you presented your case very, very well. And I laud you better than many lawyers. Not any of the lawyers here, but better than many lawyers. I think you have every right to be very pleased with your performance.
Thank you. I appreciate that, sir. Thank you.
Thank you very much. Have a great day.
You too. Thank you.